We're back here on 970 WFLA talking about the local real estate market. We got Shawn Yesner with Yesner Law, Arnie Diaz with the Diaz Duo Waterston Mortgage, and Michael Barbino, who is the broker of the Duncan Duo's Sarasota Remax office. I want to talk next, Shawn, 3 ways to protect your escrow deposit. There's a lot of misconception out there about escrow. A lot of new home buyers and a lot of new agents. What are some tips you can give people to avoid making the mistake of losing their escrow?
Yeah, I think the biggest misconception that I get about escrow is when typically it's only a fight when the contract's canceled.
Right.
And so one side, the buyer wants their escrow back, or the seller says, no, the buyer didn't cancel properly, I want the escrow. And I think the biggest misconception is both sides typically will say, well, it's clear the other side was in default, give me my money, give me what I'm entitled to. Well, unfortunately, if the agent holds the escrow deposit, if I've held escrow deposits as an attorney, or if the title company, we don't get the ability to say one side or the other is right. So we have to then put it back in the hands of the buyer and seller and say, listen, you guys agree. We can't release it until there's something in writing. So if you guys agree on what it is, we'll release the money. Even if I personally may agree, even if from a legal perspective I agree that one side or the other gets it back, we can't do it without having something in writing.
Right. And if they can't agree, then they have to go to, through a legal process to get somebody to issue an opinion over, or not an opinion, a declaration of who gets the deposit.
Right. It's called an interpleader action. And so the title company or attorney or agent, whoever's holding the money, will literally file a lawsuit where the person holding the money is the plaintiff. Both buyer and seller are the defendant. The person holding the money or the company holding the money gives it over to the court and says, Judge, you figure it out, Judge. I have no idea.
Right.
The judge will then make a decision, figure it out, and that's how the money goes. The biggest thing, too, is all real estate contracts, if they're the FAR bar or the FAR version, typically what most agents will use, has an attorney's fee provision in there. And so the plaintiff's attorney, whether it be the attorney, title company, agent, whoever's holding the money, they get their fees paid out of the escrow money that the court is holding. Then, once the judge decides buyer is right or seller is right, the losing party has to pay the winning party's fees. So when we get into these disputes over $1,000 escrow deposits,
it's really silly. It's going to get eaten up by fees.
It's going to get eaten up before
even $5,000. I think is probably reasonably going to get eaten up by a bunch of fees.
Right. And so a lot of times it's going to cause a lot less stress. It's going to be a lot easier. Just figure out some compromise and sign the agreement and move on.
I think that's what happens most of the time, but at first you get emotions that come into play, and then people that don't understand it. They don't understand that, yeah, you might win the $5,000, but you're going to, if you don't, you're going to pay $3,000 in attorney fees and get nothing out of it, and because it's the juice worth the squeeze at that point. Now, if the escrow is a big number, that's a different scenario. If we're talking, $50,000 escrow or something like that, okay. But usually we're talking about $1,000, $2,000, $5,000, $10,000, and most of the time it's just better to say split the difference.
Right.
And sometimes it's so black and white. The buyer canceled during the inspection period. Like clearly, the buyer's going to win, seller, you're going to lose this, and you're going to have to pay his fee, and you have to convince them of that. And obviously, we've had you speak to clients before because we're not lawyers. We can't give them legal advice. We have to, guide them, we have to read a contract, basically.
Right.
So
I got a great question for you, because I go along and I see it in real life here, a lot of competition for inventory, right? So the feedback I get from realtors is we need to create a contract that has the minimum amount of contingency so that the seller will sign off on it, okay?
Yep.
So if I'm a buyer and I go to you, Shawn, and I say, you know what, I want to win this bid and I want to make it easy for the seller to sign off on this, but on the flip side, I want to protect myself to some degree as well. So how would you advise somebody like that?
Yeah, I think that's something that we run into a lot, but it's the same thing, though, because if they do minimal contingencies, then maybe their escrow's at risk.
Right, and that's something that I would probably bounce back to the agent and say, you got to weigh, how much do you want the deposit to be? How much do you want the house? Now, I've seen situations where the escrow may or may not be at risk, but the buyer wants an extension on something. And so then, well, maybe we increase the deposit, and maybe we make a portion of the deposit non-refundable. So we get the house or not, but we're asking the buyer for an extension for a non-refundable piece of the escrow. And even in that situation, title company's not going to want to disperse it until the closing.
Correct.
It gets applied to the purchase price and it gets paid at closing.
I think one thing that's really important about this specific topic before we can answer Arnie's question a little bit more in depth, but we've only got about a minute before the break. But about the escrow thing is read the contract.
Right.
I mean, really read and understand the contract. A lot of people don't read and understand it, and then they go on an assumption, and they think that they should get this, or they think that, or this isn't right. That doesn't matter.
Doesn't matter.
It's what is in the contract.
If the contract says certified mail, don't send a text.
Correct.
Send a certified letter.
Correct. Yeah. Read the contract. So, all right. So those are some ways so you can avoid losing your escrow deposit. And really being cautious about it. So we're going to continue this conversation. We're going to answer Arnie's question about how to write a contract that maybe doesn't open you up to risk but puts you in the best position to win a bidding war after a quick break here on the Duncan Duo Show.